Okay, good morning everybody, and welcome to another Wednesday online seminar. Today we have Ryland Ash, our managing partner, talking about programming and time with NEC and JCT. Now we did add a couple of last minute slides to the slide deck, so if you downloaded your slides yesterday, you may see a couple different, but the new ones are on the site today for you to download the updated version. And if you can submit any questions via the chat box to me, I will make sure they're put before Ryland and he will answer them at the end of the session. Finally, we'll be releasing our June dates soon, so keep an eye out for those and sign up for any that are of interest once the dates are released. So without any further ado, Ryland, the floor is yours. Take it away.
Thank you very much, Julie, and good morning, everybody. Welcome to this breakfast seminar, which we've split into two sessions due to popularity. The subject of the seminar is programming and time with NEC and JCT, and I'm going to also cover, as Julie mentioned, coronavirus related issues in this regard. So hopefully that will answer some of your questions in advance. But as Julie says, if you have any questions at the end, then I'm happy to field those then through the wonders of our Zoom system. So for those of you who've not been to my seminars before, I am the managing partner of the firm. Before that, I started my professional career as a barrister and then turned to what I like to affectionately describe as the dark side of being a solicitor. And in my years of experience, I started off in Southeast Asia working on infrastructure and rail projects, which were turnkey in nature, which means they start with funding, deal with the planning, and essentially go everything all the way through from design down to handing back to the government an operational project. What I discovered when I came back to the UK and started working more on UK projects is that, in fact, it doesn't matter where you are, in Timbuktu or in Tottenham, the projects issues are all the same. And particularly when it comes to issues of design, development, claims, and time and programming, there are similarities across the world. So the issues today to be discussed can be generally applicable to international projects. And for those of you aware, the NEC contract is used increasingly now on international projects, albeit FIDIC is probably staking claim to being the most popular international form. But the JCT is by far and away the most popular form in the UK, and hence why I'll be looking to compare those two. So why do you need to prove delay? Well, there's broadly three reasons, and it depends on which side of the fence you sit. First of all, in terms of claims, the point to make here is that a claim for an extension of time is really more of a defensive claim. It's a claim which is brought not necessarily, it shouldn't be seen as something that's put forward primarily as something to make money. It's actually more of a defensive mechanism, and it's a defense to liquidated damages claims from an employer or delay damages claims. Now, liquidated damages will be a provision that's stated in the contract with an agreed rate of damages which will be applicable if a contractor or subcontractor fails to meet certain dates or an overall date. And those damages will be recoverable whether or not any loss has been incurred, so long as the contractor fails to meet those dates for events that they are responsible for. However, if they can claim for an extension of time under the contract, then they can have relief from those damages. So the first reason one might want to prove that delay has happened, but not just that it's happened, but that it's happened for reasons which are covered by a contractual entitlement to more time, you'll be doing so to defend a claim for liquidated damages. Secondly, you may want to found a claim against an employer for loss and expense. Now, loss and expense claims can broadly be seen to cover two aspects. One is time-related losses, such as prolongation, extended preliminaries, and the other is disruption. Now, disruption can happen in the original contract period, for example. It doesn't necessarily have to be something that is incurred in a period of delay. So this second category is more about proving delay in order to seek to recover time-related loss and expense. So if a party, a contractor or subcontractor, can show that events under the contract have given rise to an extension, a delay on the project for which they can claim, then on the back of that, they'll look to recover loss and expense for those time-related losses. But as I say, if they're looking to recover disruption, that will be a different nature of exercise. And that's something which is very specific to particular contracts. Now, if you look at the two examples we've got today, JCT and NEC, the important point to make is that under the JCT, time and money are separate concepts. So time is dealt with by way of looking at the relevant events, capital R, capital E, and money in the context of loss and expense is dealt with by looking at relevant matters, capital R, capital M. By comparison, if you look at the NEC contract, it deals with time and money together, which means that if you can establish a right to a compensation event, which we'll come on to, then you can claim both extra time and extra money. The third category or reason for which you may want to prove delay is where you need to found a claim against a contractor or a subcontractor as an employer for loss and expense. So rather than claiming liquidated damages for failing to meet agreed contractual dates, you can seek to recover loss and expense and or general damages for breach of contract where a party has failed to proceed regularly and diligently, which has caused you to incur losses, or where your contract doesn't state that there's liquidated damages, but in the alternative, you can recover general damages for delay beyond a completion date. So as an employer, you can still make a claim for delay damages, even where there is no liquidated damages provision in your contract. So how do we assess delay? Well, if we look at the JCT contract, first of all, the JCT will define what the completion date is or the sectional completion dates. And that's it. There's no contract program, as it were. The program has never been listed by the JCT as a contract document. So actually, the program under a JCT contract is largely irrelevant from a contractual perspective. The program is only relevant as evidence of what was intended and evidence of what has actually happened. And of course, it may be disputed. But the one thing we know is that with JCT contracts, when you're looking at delay issues, they're often dealt with by way of retrospective analysis, which means that it's after the event. And if you're looking at what has happened in the past, the only real way to establish what's happened is by way of reference to records. And records in the form of programs are often used as evidence or part of the evidence to prove what caused delays and what the effect was at the time. And then that's applied to whatever delay analysis approach that you use to establish whether or not there's an entitlement to an extension of time or whether it's culpable delay on the part of the contractor. So the JCT leaves things broadly open. The NEC, by comparison, is very specific. The NEC talks about, under 63.3, a delay to the completion date, capital C, capital D, is assessed as the length of time due to a compensation event, capital C, capital E, so a defined term again. Planned completion is later than planned completion shown on the accepted program. So the NEC, first of all, takes the program to be a contract document, whereas the JCT doesn't. And that's a fundamental difference. And what the NEC seeks to do is to establish what the extension of time entitlement is as the works progress. So you start off hopefully with a first accepted program, and then you measure against that accepted program, in the event of a compensation event, what your latest forecasted planned completion date is, and you measure against the last accepted program. You then get the new accepted program, and then you measure when a new compensation event comes along against that last accepted program, and so on and so forth over time. So you can see that they are fundamentally different. You're measuring against a moving target when you're looking at excuse me, at the, at the NEC contract, whereas with the JCT, you're always going back to your baseline. What was the original contract date or sectional dates to be met? So why do we have a program at all? Well, a program will be primarily for managing the works, establishing the best sequence, to manage the works to achieve the dates in the contract, but also working out where different trades are, how they interrelate, and how the whole project fits together. So for programming the works, the program is very useful indeed. It's also for monitoring progress, and that will feed into your payments. So your interim payments or milestone payments will be established by reference to the progress that's been made. And you'll have progress reports, one would hope, of those works, but that should be fed, that information should be fed into the program itself. Certainly from an NEC perspective, you'll have regular updates to the program, as we'll see as I come to the slides on the NEC contract, which will recognize the progress of the works and therefore the value of those works at any given point. But really, the most important reason for a program is in fact the basis of making or defending a claim. As I say, the evidence that's created at the time when things happen is more valuable than evidence that's created later. So for that reason, creating records, updating the program is going to be paramount for making and defending claims. And from a tactical point of view, there's an opportunity for contractors and subcontractors to create a claim or defend their position throughout the works by being selective and being tactical about what they show on programs, by only recording, for example, events that are caused by the failure of other parties or that represent compensation events or relevant events under the contract, as opposed to your own failures. Avoiding showing being ahead of program on any particular aspect of the work, because we all know what happens when you show being ahead of program. As soon as you're then faced with a delay event, the allegation's made, well, you're ahead of program, so where's the effect on your works? So being tactical about what you show in your program is extremely important. And the question which I to some degree started with, which was, well, is it a contract program? And as I say, under the JCT, it's not, unless your contract's been amended, whereas under the NEC it is. So if it is a contract program, what are the implications? And the implications are, if you imagine, that every single line in that program will represent a contractual obligation. So every time you miss a date, every time information is not provided, every time access is not provided or progress is not achieved as set out on that program, it represents a breach of contract. And if it's a breach of contract, then there are ramifications. There could be losses that are suffered. Or if you are in a position where you can make a claim, then you should be doing so and recording it on that program. But you have to follow the contract processes during that time. So does the contract contradict the program is another question which arises often early in the contract period or at the point where a delay event occurs. And the answer to that will depend on where you go next, because it is sometimes the case that there are inconsistencies in the contract between the program and the dates stated for completion. And if a contract is inconsistent or is unclear in terms of the time obligations, then there is a risk that those dates are not contractually binding. And in that situation, there would be an argument that the completion date is rendered at large. And if it's rendered at large, it means that there's no entitlement to liquidated damages, and that the contractor or subcontractor would have an implied obligation to complete within a reasonable time, which is implied from Section 14 of the Supply of Goods and Services Act. So if the contract program, if the program, sorry, is not a contract document, so the JCT example, then what should you show on that program? Well, as I said earlier, you can be tactical about this as a contractor or subcontractor. What you really want to be showing is the earliest start dates, the latest finish dates, provisional sums, and when access is required and how it's required. And then by doing so, what you are doing is you are setting up an opportunity to make claims. And it's a tactical approach, but it's one that is very effective. And what you will do is as soon as you can't get access to certain areas in a certain way, you submit notices and claims. As soon as there are provisional sums, you submit notices and claims. And of course, if you're held to the earliest start dates and you can't get access, you submit claims. And you give yourself the latest finish dates, which obviously therefore allows you more time to complete the works. So use the flexibility that you are entitled to have under the JCT form. And indeed the NEC, if you can get these provisions into the first accepted program, then that will certainly alleviate some of the risk in relation to the program generally as the project unfolds. So when should you revise a program? Well, the short answer is under the JCT contracts, whenever you can blame somebody else, or when you can rely upon a relevant event under the contract to claim more time. What you don't want to be doing is revising your program and showing when you are in delay or in default. So creating a paper trail that supports your case is fundamentally important under the JCT and thinking tactically. Under the NEC contract, you'll have contractual obligations to revise the program regularly, and I'll come on to those in specific terms later. But essentially, you can't be so tactical. The idea under the NEC contract is that you are open and transparent about the current status of the works, and that there's less places to hide in terms of delay events. The idea is that the client's entitled to understand at any given point what the realistic completion date is. And it's for the contractor to establish that if there are delays, that they are as a result of compensation events if they can. And if they can't, ultimately, they would be looking to be liable for delay damages. So you can be tactical about when you revise the program under the JCT, but under the NEC, you can equally be tactical, but the pressure is on more regular revisions. So let's look at some NEC provisions. Under 11.2, the accepted program is the one stated in the contract data, or it's the latest program accepted by the project manager. And the latest program accepted supersedes the previous one. So you can see that it's a movable feast. The accepted program is going to change, hopefully over time. And what it will do is it will reflect the contractor's entitlement to compensation events and extensions of time over that period, or not. It may actually just record the failures of the contractor over time to regularly and diligently progress the works. The accepted program is therefore a developing document. And the way that it develops is this: you essentially should have at any given point when it's updated, two dimensions. The first dimension will be the as-built progress, which should be the factual representation of the progress of the works at that, up to that point. And thereafter, there's an element of forecasting. So it's neither an as-built nor a planned program, it's both. There's two aspects: the as-built up to the date of the compensation event notification, and thereafter the forecast. And the forecast will look at when you plan to complete the works, and then illustrate, of course, whether or not there's likely to be any delay beyond the contractual completion date. So the importance really is that you get the first program right. From a JCT perspective, of course, you've got your baseline program, hopefully, which sets out what you intended to do. And every claim thereafter will be measured against that baseline. With the NEC contract, every claim is measured against only the last accepted program. And of course, that will change. But the first accepted program therefore sets a precedent in terms of what will happen thereafter and how that is to be amended in relation to compensation events. So it should set a clear baseline, should have the level of information that the contract requires. It will set out the contractor's intentions, should have a critical path enclosed in it so that it's easily identifiable whether or not an event in fact does affect the critical path. It will set out the information that's required from the employer and the project manager. It will enable the project manager to have an input into the program so that there's buy-in from the project manager. And of course, both parties are in what I would describe as the honeymoon period early on, and it's easier to agree things during that honeymoon stage, whereas later in the day, things will often change. In terms of clause 31.1, if there's no program in the contract data, then the contractor submits a first program within the period stated in the contract data. And if there is no program in the contract data, 1/4 of the money due to the contractor can be withheld until a first program is issued. So it's a very important provision that if it finds its way into the final contract, and it's also a fairly substantial stick for a contractor to waive in front of for an employer to waive in front of a contractor to ensure that a program is provided. In terms of the information that is to be provided in the program itself, 31.2 is very thorough indeed. You can see that it talks about start dates, possession dates, key dates, planned completion, the order and timing, sequencing, but also the order and timing of works by the employer or others, as last agreed, or if not agreed, as stated in the works information. and the dates by which the contractor plans to meet conditions for key dates or other work that is required to be completed before a contractor can proceed. There's also provisions for float, time risk allowances, health and safety requirements, which is obviously very relevant at the moment in terms of the changing environment and requirements for coronavirus, and the procedures set out in the contract, dates by which the contractor needs access, acceptances, plants, materials, and information for others. And further, for each operation, a statement of how the contractor is to undertake the works and any other information required. So you can see that just by reading that list, that the program under an NEC contract is very much more of a detailed document. It goes beyond just a planned forecast for the sequencing of the works. It is very much a broader collection of documents. And of course, every time there is a delay event, there is a requirement then to revise all of those documents, or the documents that are relevant that need to be amended. And therefore, there's a lot more administration involved in that process. And it's been said to me that you need at least 20 to 25% more resources to actually run an NEC contract properly in view of these requirements in relation to planning, early warning notices, compensation events, and so on. Under 32.1 in the NEC, the contractor will show on each revised program the actual progress achieved for each operation and its effect upon the timing of the remaining work. So that's the as-built section of the program, or dimension of the program, as I mentioned earlier. And then you've got the how the contractor plans to deal with any delays and to correct defects, and then any other changes which the contractor proposes to make to the accepted program. So that's on each revised program, which is going to be a regular occurrence if the contract is run properly. Next, I've taken you through a number of the changes that are in the NEC 4 contract, because I'm conscious that many of the larger contracts, at least, that were placed earlier in this year and perhaps last year would have been under the NEC contract, or a version of it with amendments possibly. But the NEC 4 new form is now becoming more widely used. So I thought I would highlight some of the changes brought in by that form. So the first thing, this is not a change, but this is an important point, that under the NEC contracts, there's no separate provisions for extensions of time, loss and expense, and variations and claims. They're all compensation events. And under the NEC, you cannot make claims at common law. The rights of the contractor to claim for compensation events are their only rights. So if you don't have a right to claim for a compensation event, I'm afraid that there would be no right to make a claim at all. In terms of revising the program under the NEC, these are to be submitted to the project manager for acceptance or not. And they are to be submitted to the project manager, and then within the period of reply, which is stated in the contract, project manager then has the power to instruct the contractor to revise the program within that time. When the contractor chooses to, they can revise the program if, say, for example, an event like the coronavirus occurs, or some other event which is likely to impact upon the works, or obviously where there is a compensation event. But in any event, at no longer intervals than the intervals stated in the contract data from the start date to completion of the whole of the works. So the contractor has this obligation to regularly submit and update the program throughout the works, which of course is not the case under the JCT. Now, in terms of quotations for compensation events, it's important to note that because compensation events entitle in principle the contractor to claim time and money, there's no distinction between cost neutral events, for example, under the JCT, such as exceptionally adverse weather or statutory requirements. So under the NEC contract, where there's a compensation event, the contractor can submit, or must submit a quotation, and that quotation under clause 62.2 shall comprise proposed changes to the prices and any delay to the completion date or key dates. And if the program for the remaining works is altered, then the contractor includes alterations to the accepted program. So it's clear time and money are dealt with together. So not only is a contractor obliged to continually update the program, notwithstanding compensation events, but also in the event of compensation events, as soon as a quotation is required, the contractor should be submitting revised programs with those quotations. So in terms of timing of this, and this is where the NEC comes in for some criticism, you've got a period in the standard form of 3 weeks for the contractor to submit that program from being instructed. And then the project manager is to reply within 2 weeks. So 5 weeks have passed before you get a response. And often the works have moved on within that period. And that can become frustrating, most importantly for the contractor, because they're looking to get assessments made and to bring in money, in particular at the moment when cash flow is tight. So these delays can be quite painful, but obviously you're free to agree different time periods in your contracts at the early stage prior to contract formation. But in the reply, the project manager should then respond after 5 weeks, saying that they either accept the quotation, instruct the contractor to revise the quotation, or that the project manager should be making their own assessment. And they're broadly the three responses. And so within those 2 weeks, the contractor, the project manager can also say, in rejecting the program, that either one of 4 reasons: either they think that the plans shown are not practicable, 2, that the program does not show the information that the contract requires, well, that they need to explain what information is missing, 3, it doesn't represent the contractor's plans realistically, well, they need to explain why, or it does not comply with the scope, and again explaining why. Now, if a project manager rejects a program for a reason not listed there, then it becomes an additional compensation event, which then the contractor can value and claim for. And equally, in my view, if a project manager responds without explaining why that they've made the decision to reject a program and explaining in detail the basis for that decision, then again, I think it's likely to be seen as a separate compensation event. And so contractors should be alert to that. Equally, project managers should be alert to that and making sure that they stick to the program, stick to the wording of the contract and explain their decisions at each stage. And I've highlighted at the bottom here some changes that were made in the NEC 4 contract that were not in the NEC 3 or previous versions. And this is a default position, a default provision which says that if the project manager does not respond to the revised program for the period, within the period of reply stated in the contract, then the contractor has to give a notice to the PM. And if that notice is ignored for 1 week, it's quite a short period, it's then treated as the new accepted program. And at that point, a contractor can then argue that, for example, compensation events and the impact of them shown on that program have then been assessed. and therefore maintain claims for time and money. So it's a very, very important change to clause 31.3 in the NEC 4. And what that does is it closes up some of the criticism that the other forms had, whereby ultimately this process went on and on and on, and there was never any conclusion to it. But now there can be. Of course, it still requires that notice from the contractor telling the PM that they've failed, and then the further week passing by. In my view, if the contractor doesn't give that notice saying, well, you failed to assess my program properly or in time, then they won't be able to rely upon this default provision. So really, in summary, in terms of programs under the NEC contract, each accepted program is a very important document. It's a contractual document. It's something that has contractual effect, unlike the JCT contract. It's more evidential. It goes far beyond a simple management tool. It's to establish ongoing entitlement to extensions of time and loss and expense, time and money together. It's also an important record of what's happened throughout the progress of the works. The accepted program is the basis for any assessment for an extension of time in relation to the difference between the last accepted program and the planned completion date at that time. The project manager cannot simply ignore each program, but must either accept or reject them, giving reasons as stated in the contract. And if they fail to do that, or they give reasons otherwise, then it's another compensation event on top. If the project manager wrongfully rejects, it will be a compensation event. If the project manager does not properly reject, they'll also have to make their own assessment. And that's an important provision, because often there are questions from project managers put to me saying, well, what can I do if the contractor's just simply not updating his program properly? The answer is you make your own assessments, and you assess on the basis of the information you've got. And if a contractor can't prove that they are entitled to compensation events, but they're in delay, then ultimately you create a record of there being a culpable delay on the part of the contractor. And if that's left unchallenged, that would be persuasive evidence if there's a dispute later. In terms of how you assess the delay, the key point here is that under the NEC contract, the entitlement of the contractor to an extension of time will be based upon what they are entitled to as a reasonable forecast at the time of the compensation event. So it's not about, well, what was the actual effect retrospectively, and what actually happened, again, is not alone going to be decisive. What's important is what was a reasonable forecast. But the reality is what actually happened will be a good indicator as to what could have been reasonably forecast at the time. But ultimately, it will be based upon the entitlement of the contractor will be based upon what was a reasonable forecast for the delay or an extension at that time. In terms of the coronavirus, what I've done is I've identified what I consider to be the relevant compensation events, starting with an instruction to change the scope of the works. So that's a broad provision, which means that it generally can have wide applicability. If you've received any instructions from project managers or employers in relation to the works as a result of coronavirus or otherwise, then you can certainly look to rely upon those instructions as a change, if it is indeed a change, under 60.11. And a change could be a change to the conditions of the site, the way in which the works are undertaken, by way of social distancing, for example, changes to access or the way that the works are undertaken, or the mode or method statement for those works, and so on and so forth. So a broad scope there for claiming for time and money in that regard. The client does not allow access. Well, that's straightforward under 60.12. 3, the client does not provide something on the accepted program by the date stated in it. That could be a permission, could be a decision, it could be access, it could be anything that's on the accepted program. So again, fishing through programs, looking at what needs to be done, are all exercises that can be done now, and particularly if works have stopped on site, these are the types of things that should be investigated. Under 4, an instruction to stop or not to start work. Of course, suspension and instruction it is clearly something that falls under the compensation event 4, or a change to a key date, again, would be a compensation event attracting a claim for time and money. 16, the client does not provide materials and facilities for testing that's required, is specifically a compensation event. And then finally, a breach of contract by the client. So an act of prevention stopping you from completing the works. So they're the broad compensation events that I think are relevant to the coronavirus, but many of them relate to instructions or decisions being made by an employer or a project manager. As an employer or project manager, the key to avoiding liability for time and money claims is essentially to put the onus back on the contractor to make decisions about how the works progress. And by doing that, you obviously avoid triggering the compensation events themselves, but some of them are going to be unavoidable, I'm afraid. There is another one to mention, which is not on the list, which is option X2, which is changes in law. And I'm going to come on to changes in law post the base date or the exercise of a statutory body power when we talk about the JCT contract. But changes in the law have been made. There are new regulations in relation to the hospitality industry and closing restaurants and bars, but not in relation to construction projects. And then furthermore, we also now have the Coronavirus Act 2020, which came into force. And under that, there's a specific power to close sites. But as I understand it, not many of those instructions, if any, have been given by statutory bodies. Rather than give those in specific instructions, they've created more indirect restrictions or put the onus back on the employers, the stakeholders, and the contractors ultimately in control of the sites to ensure that the regulations and guidelines can be met. So ultimately, at the moment, there isn't very much in the way of clear-cut grounds for claiming for changes in law, but certainly there will be examples where that does apply. And the last one in relation to the compensation events under the NEC is the force majeure provision, as I call it, under 60.119. It doesn't mention force majeure, but it is very much akin to a force majeure provision, which is an event that neither party could prevent and something that at the contract date, it could not have been reasonably foreseen. Now, of course, in relation to predicting the effect of the coronavirus, I think it's fair to say that if your contract was entered into prior to probably around the end of January, when Wuhan was locked down by the Chinese government, that it was not reasonable for you to have foreseen the events that unfolded. Whereas if you're entering to new contracts now, of course, we all know only too well that the virus has taken hold and what impact it may have. So for new contracts, I strongly advise that you take specific advice on the types of provisions that you've got in your contract. And I think the long and short of it is to look at trying to legislate for the effects and look to share the risk. Share the risk of closing the site, delays in the progress of the works, the supply chain issues, labour supply issues, and also obviously health and safety being a priority concern, something that in the contracts I have seen amended tends to be put firmly as a risk on the contractor. But by balancing that out, I've often seen the fact that funders and employers have been more flexible to accept the risk in terms of delay. So there's a trade-off to be made, and certainly we'll see more guidance on that in due course. And it's worth noting that if you look at the FIDIC contracts, again by way of example, there are more provisions, more detailed provisions that relate to pandemics, epidemics, and circumstances of this nature, because in the past few years there have actually been a number of outbreaks that are similar to what we're seeing now, albeit on a lesser scale, in relation to things such as bird flu, swine flu, Ebola, Zika virus, and of course SARS as well. So these types of circumstances have happened before, and contracts are evolving, but the FIDIC forms are probably ahead of the game in terms of those provisions, but more work needs to be done and specific advice taken on new projects. Now, comparing those provisions with the JCT is sort of day and night, really. The JCT is very simple insofar as it sets out a date of possession and then a date for completion. If you've got sectional dates, then of course you may have more than one date for completion. But that's it. And it's down to the contractor as to how they're going to sequence and program the works. And I'm often reminded of when I was in Beijing in 2008, just before the Olympics started, a couple of weeks before the opening ceremony. And I remember walking around seeing a number of building sites, essentially, around the Olympic stadiums where the car parks and roads and infrastructure simply weren't complete. And I thought to myself, well, how on earth is the government going to finish this work in time? But lo and behold, a week and a half later, watching the opening ceremony, you could see that they had finished that work. They'd finished it incredibly quickly, and they probably moved heaven and earth, or more specifically, people and earth, and farms and whatever else they needed to move to get things done. And I'm still not sure whether or not some of that was computer generated, but I guess we'll never know. But the reality is that there is a degree of flexibility under the JCT about how a contractor wants to get the work done. And as long as they meet the completion dates, they're not in breach of contract, unless it's very, very obvious that there's a failure to proceed regularly and diligently. But if a contractor can come back and say, well, I don't need to start on the date that's in the contract because I'm confident I can get the work done in any event, and therefore at that point they're not in breach of contract, not clearly anyway. So looking at the case law on this, Wells and Army and Navy Cooperative Society from 1902, the courts of England and Wales set out that the contractor is entitled to plan and carry out works to suit itself unless the contract says otherwise. So it's very much in the benefit of the contractor as to how they're going to program and plan the work, and that degree of flexibility still stands today. However, it is worth mentioning that the courts in 1987 in the Glenlyon Construction and Guinness Trust case made it clear that although a contractor may wish to or plan to either start late or finish early, because they're entitled to do that, ultimately, if they decide to do that, the employer and the obligations that they have to the contractor will not be adjusted. So in other words, if there is an early completion date planned, and this is often the case, and this is what my next slide is about, even where that early completion is approved by a contract administrator, ultimately, following the Glenline and Guinness Trust case, the court said that there was no implied term that the employer should have to have any obligation to facilitate early completion. So it's up to the contractor, but it will not affect the obligations of the employer. Now, that's the case, and that case would apply to the JCT contract squarely. But it's worth noting that the NEC contract is obviously a different kettle of fish, because under the NEC, we have this accepted program. And the accepted program has contractual effect, which means that the parties have agreed that those provisions can be amended, that they will change over time, and that the parties will be bound by those changes and potentially bound by them just by default, as we've seen in the NEC 4. So the reality is that these provisions in the case law stated here may not have applicability in terms of the NEC contract. Under the NEC contract, obligations may indeed change over time, and an employer may find that in accordance with a new accepted program, they have obligations to provide things earlier than they originally anticipated, and if they don't, they'd be in breach of contract. Now, it is worth mentioning also that from a contractor's point of view, it doesn't work both ways. So a contractor would not have an obligation, for example, to complete early, even if the accepted program shows that earlier date, because the reality is that compensation events can only change the completion date to a later date. And so a contractor, even though there is a new accepted program that shows an earlier date, a contractor is not going to be liable for missing those dates, because it can't be any earlier than originally agreed. But there is an exception to this. If the parties make a new agreement, such as an acceleration agreement, for example, where it's instructed and agreed, then of course that would be given effect, because the parties have agreed that it would effectively supersede what's in the contract. And if there's an acceleration agreement, an instruction, and then an agreement between the parties for acceleration, then the obligations of the parties would change. So as with a lot of case law which relates to interpretation of contractual terms, they will be subject to what the specific contract actually says. So in terms of the JCT contract and coronavirus, what I've done here is set out the relevant events which I think are relevant to what is happening at the moment, and which would entitle a contractor to an extension of time. So the first concept to look at is force majeure. Now, it's important to note that force majeure is a French law concept, and it's not something that was developed under the English courts. And for that reason, you as parties are free to define what force majeure may mean. And so be careful that there isn't a definition in your contract that excludes circumstances such as the coronavirus, which is possible. So it comes down first to the definition. But in the JCT contracts, for example, there is no definition. And because there's no definition, ultimately we have to fall back to interpretation and case law. Now, there is very little case law on specifically what force majeure means, particularly in relation to construction contracts. But I have managed to find a case which is relevant, which is the Clifford Gardner and Clydesdale Bank Limited case, which is in the slides that will now be available to you, from 2013. Now, this wasn't the operative or the key part of the judgment, but it was said by the judge that a flu pandemic in that case was a force majeure. And so that will be very useful when making arguments in relation to the coronavirus. The next ground that I've identified is the exercise of statutory powers, which I mentioned earlier when I was talking about option X2 and changes in law under the NEC. Now, specifically, I've put reference in here to the Coronavirus Act and Section 52, which is set out in more detail in Schedule 22 of the Act. And in there is a power to close premises in England or impose restrictions on persons entering or remaining in them. So clearly there's a power, it's a statutory power, and if it's exercised in relation to your project, then in my view, it would fall under the relevant event under the JCT. An instruction to suspend works or to stop or not to start is clearly a relevant event as well. Equally, an instruction to change the nature of the works would be a variation, which would also be a relevant event, which would entitle you to an extension of time. And then finally, acts of prevention or breaches by an employer, which could include preventing access to the site or withdrawing or not providing approvals and any other information that's required. So general breaches of contract, perhaps even non-payment, would come under the final category. And therefore, there are a number of things here under the JCT contract that represent relevant events, which in relation to the coronavirus should give a contractor entitlement to an extension of time. But it is worth emphasizing that not all of these events entitle a contractor to loss and expense. So it's time and no money. And the key example of that is the force majeure provision. There would be no entitlement to loss and expense under the JCT contract, even though the concept of force majeure is not specifically defined in the JCT contract, and it's probably applicable to the coronavirus. But in terms of changes, variations, they would be caught by the loss and expense provisions, and equally so would breaches or acts of prevention. And therefore, there is still scope to claim loss and expense in relation to the coronavirus in certain circumstances under the JCT contract. So that's the end of my presentation. In conclusion, I would say that there are three key points. One is that you must look at the contract terms very carefully and spend this time, if you are away from site, considering what risks, what obligations you have, and whether the relevant events would apply, whether the compensation events would apply to the circumstances that we're currently facing. Second is that be careful what's instructed from an employer's point of view and project manager's point of view. Don't unnecessarily give instructions which will give rise to claims. There is a way to essentially put the obligation back to contractors and subcontractors and say, well, it's your site, they're your works, you're under an obligation to continue. How do you propose to deal with the situation? And what that may do is avoid liability for loss and expense. And in particular, you might find that you restrict contractors and subcontractors entirely to claiming force majeure, which of course they're likely to be able to prove may cause a delay, but ultimately will not be entitled to loss and expense. So think about instructions before they're given. I've seen some examples recently of parties issuing instructions to suspend works and then following up with further instructions saying, oh, by the way, this is an instruction under a different provision, which will not entitle you to loss and expense. Well, I'm afraid it's too late. If the instruction's been given under the other provision, which does entitle loss and expense, then you can bet your bottom dollar that contractors are going to rely upon it. And in my view, they should succeed. So that's the second point. And the third point is about records. it's absolutely fundamental to ensure that you keep detailed records of A, the timing of events, B, the details of the effect of those events, and C, obviously the costs, the ongoing costs and losses that are being suffered. And, you know, as part of that, it's important to submit notices, early warning notices, compensation event notices, delay notices under the JCT, notices of loss and expense. All of these things should continue to be issued at this time so that there can be regular updates. And really, finally, what I would say is that nobody at this point knows exactly which way the courts and adjudicators and third parties are going to view these issues. But the one thing I would say is that parties should try and work together if they can to seek to resolve the problems that are ongoing and to seek to come to agreements about how they're going to be resolved, and be realistic in your expectations, because it's much better to deal with these things up front, forecast what's likely to happen, and come to sensible commercial arrangements, because the alternative is really doesn't bear thinking, but termination of contracts, claims, dragging them through the courts, if the courts are even going to be able to deal with claims. I know they're doing their very best, but there are delays. All of these things are probably not in anybody's interest. And of course, when cash flow is tight, to be spending money on, you know, contentious matters and disputes is difficult. But what I would say, just one caveat to that, you know, if you are owed money or you're not being paid, don't sit on your hands too long. If you can't get commercial agreements in place, then you must act swiftly in seeking to try and recover your money, because the longer you wait, the less chance there is that you're going to be able to do so. So thank you all very much for listening. I hope that's been useful. And I believe I'm going to hand over to Julie for some questions. Julie.
Indeed, we have some questions. Okay, first up is, if a program is included in a JCT contract, does it make the employer's position any stronger when the contractor makes an EOT claim?
Okay, well, first of all, you need to look at how the program has been incorporated. So I often see, for example, a situation where a program is included within a contractor's proposals. If it's in the contractor's proposals or somewhere in the scope or even in the employer's requirements, it doesn't necessarily mean that it is a binding contractual program. The obligations in relation to time under the contract will be dictated by what the contract says specifically within the time provisions, within the operative time provisions. And that will be in the particulars. The particulars will say completion date of X, and that's it. And now if that doesn't make reference to the program, then it doesn't matter that it's in another contract document. It will be neither here nor there. All it is an indication of what was intended, but it's not binding in the strictest sense. Now, as to what value it has, well, if it's not a contract document, then as I say, it's just evidence. And so is it in the employer's interest or the contractor's interest? Well, I would say ultimately it's in both parties' interest to have an intended program, you know, because without one, ultimately you're going to have to make it up as you go along or after the event, which is no good to anybody really. It's more hard work and more expensive. So having a clear intended program is always going to be a benefit. It depends what's in that program. Now, if the program shows, for example, that an employer has to provide information by dates which are frankly unreasonable, then of course that's bad news for an employer, because a contractor is going to rely upon that and say, well, look, here was the intended program. You haven't given me my information. These are relevant events which entitle me to extensions of time. Equally, by comparison, a contractor wants to try and ensure, as I mentioned earlier in my slide, that they've got the earliest start dates, the latest finish dates, and you know, requirements for information as they go along and access to the site as they need it. And if those things are stated in the program and they're quite express and clear, then that's going to be in the benefit of the contractor, because they're the types of things that often change. Whereas if they're not shown, then in many ways the employer is in a better position, because it can argue that those things are not directly relevant, and ultimately it's for the contractor to manage the risk of all of those things, because they've agreed to complete by the completion dates that are in the contract.
Okay. Next question. How should a revised programme be presented for approval? Is it acceptable for this to form part of the contractor's report presented at a monthly progress meeting? Equally, is it acceptable or advisable for a project manager to accept a programme through a record of the meeting or meeting minutes?
I think the reality is you've got to be practical about this. If the parties agree that they can be submitted as part of other communications, particularly in today's circumstances, with people working from home and using computers for most things, then I think that's absolutely the right way to go. Try and seek agreement and say, look, you know, is this acceptable? And ultimately then you'll avoid arguments. In terms of what the strict contract will say, well, if we're talking about the NEC contract, the NEC contract does specifically say that communications and notices should be issued separately under, I think, clause 13.1. And so for that reason, you do need to be careful that revised programs are issued separately. And if they're not, then there could be an argument that they're not valid. So seek agreement, otherwise follow what the contract says and issue them separately.
Okay. Can liquidated and ascertained damages be expressed as a percentage of the contract sum per week? One of our viewers has seen a consultant's drafting of a contract with the LADs expressed in this way, and they were wondering how this can be argued as a genuine pre-estimate.
Okay, so that's a good question, an interesting subject. The first point is that for a liquidated damages provision to be valid, it must not be a penalty. And this goes back to the 1915 case of the Dunlop Pneumatic Tyre Company, and the fact that the courts decided that liquidated damages, in order to be valid, have to be a genuine and reasonable pre-estimate of the loss. But the courts have slightly changed their view on this. The Supreme Court ruled a couple of years ago in relation to a joint appeal involving Cavendish Square and Private Eye, I think it's called the parking ticket fine case, that in fact that concept can be slightly modified. So although it needs to be a genuine and reasonable pre-estimate of the loss, it can also be an amount which is justified for commercial reasons. So if there are commercial reasons by which an amount stated in a contract can be seen as reasonable, then it will be seen as valid and it won't be seen as a penalty. And in terms of a percentage of the contract sum, well, the question will be, is that percentage either a genuine and reasonable pre-estimate of the loss, or can it be seen as something that is commercially justifiable? And if the party who's put together the calculation can show, broadly speaking, that that percentage is appropriate and that it is either a genuine pre-estimate or commercially justifiable within that context, then ultimately that figure may well be considered to be valid. But I would say a word of caution, you know, a straightforward standard percentage of the contract sum may come under some questioning unless you can show how it's been calculated with reference to what would be estimated to be a genuine and reasonable pre-estimate of the loss.
Okay, next question. Who owns the float in a JCT?
So in the JCT, it's the first party that claims it. So if you're a contractor, then get in there first. And under the NEC form of contract, arguably the contractor owns the float, because the contract states that the contractor shall allocate the float as part of their revised programs.
Okay. The extension of time assessed under the NEC is based on reasonable assumption rather than actual. What is the actual delay? Is it different with the reasonable with a reasonable assumption?
So if I understand the question, it's the difference between actual delay and the reasonable forecast.
Reasonable assumption.
Yeah. And so the point I made is that under the NEC, I think as the question states, that the correct approach is to look at what the reasonable forecast is. So in looking at whether or not a forecast was reasonable, what you can do is, if it's after the event, of course, you can look at what actually happened and say, well, I forecasted that this would cause a delay of, let's say, 10 weeks. And what actually happened is that it caused a delay of 12 weeks. Well, if the 12 weeks is not far off the 10 weeks and the reasonable forecast was 10 weeks, then the argument would be, well, actually, the forecast was reasonable. And so what actually happened is not really in itself relevant. The question is, what was a reasonable forecast at the time based upon the information that was available? And if you test that against what actually happened and it seems reasonable, then that would be the correct approach.
Okay, just had a last minute question in, which is actually relating to COVID, so it might be quite interesting to get your feedback on this. Are you able to provide an example where an extension of time, COVID related, can be granted, however, no loss and expense applies? Wouldn't a contractor be entitled to extended prelims with time extension?
So the example is force majeure under the JCT. And force majeure is a relevant event, which means that the contractor gets an extra period of time to complete the works in relation to the delay caused by the coronavirus. But what the contractor will not get is any preliminaries, any disruption, or any other loss and expense, because it is not a relevant matter under the JCT contract.
Okay, just a couple more questions to tax your brain with. Can the project manager take into account when the contractor submits another compensation event at a later stage?
So the situation with compensation events is that they ideally should be dealt with one at a time. And the impact of the first compensation event should be taken into account, and then the program revised accordingly. If another compensation event occurs later, after you've got a revised program, then that later compensation event will have to be assessed based upon the impact it has on the last accepted program, which would have included the impact of the previous compensation event. So you would move the baseline based upon the impact of the previous compensation event first, and then you start afresh from that line and say, right, from that new program, now does this second compensation event, further compensation event, impact upon the completion date? And if it does, what is the reasonable forecast of the impact, and measure that against the previous accepted program?
Okay, the penultimate question. Does the Cygnus report in 2016 foreseeing the risk of a viral pandemic render the government negligent, and does it supersede the 2013 case concluding a flu pandemic force majeure?
Well, as to whether or not the government's negligent, I suppose you could say that certain people are, because you know, if you're made aware of something and you don't do something about it when you ought to have, then that is a failure in a duty. As to what you can do about it, there probably isn't a great deal. Yeah, whether the government's negligent or not, I don't think it's really going to change from a construction perspective. Any remedies that are available to you. So I think it's sort of separate issue, really. It's an academic point. But it, you know, in terms of the latest pandemic, I still take the view that you know, there can be reports on all kinds of risks in relation to projects. Is it fair and reasonable to say that a contractor ought to have been aware of all of those risks, whether or not a government's taken steps to mitigate against them, whether behind the scenes or otherwise? I don't think that is reasonable. I think ultimately what is reasonably foreseeable at the time when you enter into a contract must be based upon what is publicly available, but what is also directly relevant to that particular project. There's no infinite duty to go out and investigate everything that could possibly go wrong. And that's where the word reasonable comes in. You know, was it reasonable to go back and look at such reports and factor those in to the progress of the works? I don't think that is reasonable. So the timing of reports, how far and wide they are reported, the importance that they're given, the response of the government as well, I think is a relevant factor, linking it back to the first point. But, you know, if the government's missed it and they haven't told us all to prepare for it, then ultimately I don't think it was reasonably foreseeable.
Okay, and final question. Does the latest accepted programme under the NEC contract supersede that in the contract data baseline? And what is the impact if there is conflict between the two?
Well, the answer is yes, it does. It supersedes the programme in the contract data. And the contract is very clear that the latest accepted programme supersedes the previous, including the one in the contract data. So the effect of that is that you've got a continually moving baseline programme for the works. And in agreeing new accepted programmes, you are effectively agreeing extensions of time if the programme shows delays as a result of compensation events. And therefore, a contractor, if there is a change to those dates as a result of compensation events, pushing the completion date later, contractor is going to be entitled to not only the extra time, but also the extra money as a result.
Okay, thank you very much, Ryland. That's a lot of questions answered there, so thank you for your time on those. Thank you everyone for joining us this morning. We hope to see you virtually again soon. Stay safe and keep an eye out for the June dates, which we release soon. If any of you do have any questions or would like further details, please don't hesitate to contact Ryland. The contact details are both on the website and on the slides that you can download via your joining instructions sent out yesterday. So please feel free to contact him if you've got any other questions on the issues covered today. Otherwise, we'll see you all again soon. Thank you very much for joining us. Thank you, Ryland.
Thank you, Julie, and goodbye, everybody.
Thanks, Ryland.
Okay, Jules, thanks very much.
See you soon.
Bye now.
Bye.